had to make appearance a day before Mr. Kanja was sworn in, and the release. Indeed, indeed, my lord, I must thank you for that. The gravity of this whole matter, and therefore I'm not going to talk about gangsterism, but I will insist so that the rule of law in this country will be seen to prevail. I thank you.
Therefore, we thank you, my Lord, for focusing on what is most important, to ensure that it is sufficient. I think that's what we have agreed with the rest of the petitioners present. Let them be able to, between anarchy in this country, arbitrariness, do not stand in accordance with the Constitution, then our country will fall into anarchy. And so, okay.
Yes, in 1 minute, and I'm glad that you have signed, or rather to take it back to petition the miscellaneous criminal application. Application that your brother had placed before you for purposes of determination, if it would be in order to just include Kevin on the Inspector General as well as the rest of criminal investigations. Yes. We have been served
once.
Yes.
In my view, I do not find the statements recording, squaring out the proceedings before you. For one reason, my lord, that the petitioners' affidavits, those that were able to secure, your lordship, the ordeals that they went through, who abducted them, and that's the process this court will be engaged in. Us requires to put in supplementary affidavits to the affidavits from our clients' criminal justice system, which is completely as a separate proceedings, which are so unique in nature that we take to the stand. Because examining those individuals, we need to cross-examine within the limits inviting individuals for cross-examination. One of the individuals that I'm inviting is may be relevant in assisting the court to go to the depth of this matter. Number two, your lordship, is Mr. from government.
My lord, sorry, I know the court gave directions, but please guide us. On the side of the rest investigator who was brought by Mr. Nyamoti in the court, who will tell us the least amount of times, because beyond recorded may give leads which the police may want to follow. Those leads cannot be followed in one day. So we pray that on the part of the audience, that release which the petitioners have chosen to call production. Lord, I will not say so much, but I want to share with you a decision of the Supreme Court of this country. The state of Mwangi Stephen Murinji and the Abu Joan Mohammed SC suing as the executrix of the estate of Honorable Daniel Toroitich Arap Moi, and was never fashioned to grant leave beyond release of a person from unlawful custody. The grant or denial of the writ does not deprive an. The matter ends, which I accept. To the question of the seventh petitioner, I urge you to agree with me, and thank you.
Hold somebody for 2 years, a year. That's the reason as to why 2010, the Constitution of Kenya made it very clear that if anybody's held means of the charge sheet or a miscellaneous application for custodial case.
Yes.
If it extends to look for violations of my good brother, which has put it very clearly, moves to investigations. My lord, number two, look at the constellation of the officers before you, starting from the Inspector General of Police. Deals with intelligence becomes a subject matter on abductions. My lord, I urge you to look at the scope, show that the DCI has the person who has not, that it is not released from police custody. None or anybody has produced evidence that they were released from a police station. They are here. In this we are in the dark, my lord. We urge that be a concern for every Kenyan, not only the police. Is that somebody missing, already dead? Is that somebody missing in the hands of government agencies? That will take time. And that's why I agree with my brother, Mr. Nyamodi, I agree with Nyamodi that 14 days will be sufficient to bring to you a status report that the court can make a decision on.
Yes, my lord. Your lordship, of the 7th rescue. Perhaps I have listened and Lord, everybody seated at this bar, undermining the authority of this court and the orders that you issue. And perhaps for here for 2 days. Compliance with order number 3. That is the appearance of the inspector, bearing in mind that my lords, they are ex parte orders that have been issued by this honorable court. And for example, application of order number 3, that if the court maintains that it is Mr. Nyamodi is asking for, we hear the notice of motion application. So that, and my lord, bearing in mind that the enforcement of rights is under Article 25 of the 7th respondent, and we have filed a reply to that application, my lord. If you allow, can pass that application, so that you are going to renew a ruling, because this is a court of record. So that within the requisite number of days we give findings based on the aspects that will be responded. Therefore, to me, to my mind, I believe, without to underscore the importance of the matter before you, we still have the other miscellaneous application number 216.
Yes.
Where if, for example, orders of at least the respondent to look at the material that have been placed before and make an informed decision as either to the continuous appearance of. And I say that, my lord, with tremendous respect, because under Article 245 of the Constitution, by the first interested party, the second interested party, in terms of enforced disappearance, the Inspector General of Police, by the affidavit that have been filed, that they are. What I foresee, my lord, is that given especially if at all what is alleged that the state actors are holding this person, the first respondent under Section 6 of, and the dispute ultimately will come to the judiciary for determination. My plea, my lord, that we hear the notice of motion application to
Omtatah.
Yes, my lord. Yes, my lord.
Yes.
Before I answer the question of time, it's people, their rights, freedoms, property, other national interests. So, my lord, I would request that when you talk about the application for the release of this raid, that article to the end, and also look at Article 2. Who are listed there. So the application by the is calling upon the duty bearers to perform their functions. And so the internal threat, police who are listed as the security organs, the NIS, and even the military, ends the way I've not had a law, for me, is Article 23. Where applications for enforcement of rights, where the court doesn't given the power to, the power the court has been given,
yes,
under Article 23. Yes. The other thing, the power the court is. First of all, it will be a bit difficult to say that. It's another problem.
yes.
That these people don't deserve any time. It's not acceptable that the number 7 entire day when it's not known where he is, and people are asking for time to investigate when the person on 24th. Because one of the people was abducted after leaving my office. I went and made a report about Quebec. Petitioner is not here. And the Inspector General of Police comes in person. Law enforcement. And then if you tell us why he cannot deal with that internal threat, that he earns a salary.
Go, Mr. Shio, Mr. Wanjiru, then
so that you can proceed effectively.
thank you. So very briefly, so one more time, it's a simple question.
And then the speaker to us so that we close this side. Now we associate to Mr. Lemoni for a minimum of 14 days for practical and procedural reasons. The first respondent to investigate and at least have a progress report on that position that received only 1 day. Secondly, my lord, we would like to, for procedural propriety, flows from order number 1. Order number 1 presupposes it has now been established, and my lord cannot ignore this fact, that indeed.
They just say the days, you can give a very brief 30-second justification.
Accordance with the court's order, they were held for more days. The request to come back 14 days later is to every second in custody is an additional segment. It's a continuing violation of the right to be brought before a court of law by the court of these Kenyan citizens. Thank you, my lord.
Thank you. Mr. Kumar?
Just 1 minute. When the IG would be appearing in person, that is what the court angled. There have been no offer, none at all. Well, what we'd like to do is first to agree with the
Karua?
Thank you, my lord. I agree. Order to appear before you must appear. And I argue that they don't need more time. And the 7th petitioner needs also to be set at liberty.
It's not only a question of time, but the directions you gave earlier that will be supplied with the documents that look like registration certificates. They do not look like documents that are and lastly, Your Lordship, perhaps the Director General should appear equally in person.
15 is a partner in his money.
Yes.
On the issue of we suggest 1 day agree with the seniors. For reasons being, Article 25, we adjourn, the longer he's in jeopardy. And that is a direct infringement on his right in terms of delegation of the interrogated in terms of the victims. So Your Honor will be paying for 1 day maximum.
stamped its authority, perhaps a move that led to his reproduction. No, my Lord, on the 6th day of January 2025, when my client was presented at 2 p.m. at Ngong Police Station. For that reason, I will wish to fully associate myself with the submissions made by my seniors at the bar. Yes. Still cries out loud for the court to help in the reproduction or the production of the 7th petition.
My Lord, may I just have 30 seconds running here on Friday for two simple reasons. The statements and the respondents have admitted that they have been going on with the investigations. So there is no need for keeping the email. My Lord, that is a right that cannot be limited in any manner whatsoever.
My Lord, if I may.
Yes.
I have not spoken for the first interested party.
Yes.
I think we associate ourselves fully with this.
Not obscure. The central question before the Apex Court was whether if you apply for habeas corpus, you cannot thereafter apply mystic but in competition. The second to sixth petitioner applicant. I understand that we're all eager for an expedited hearing process. I've heard persons say that we can record statements this week. And Council Jiru mentioned supplementary affidavits. That's the other concern. This court must give sufficient time for the petitioner persons to too much time. It cannot be that because the second to why the IG is important. I believe it was Council, I think it was Jiru last time, the second and third respondents have done, but also has nothing more important, Mr. Mimodi, than dealing with what is perhaps and you will need to draft supplementary for the country, but to assist the third respondent to coalesce all these statements. Perhaps we should try to make it easier. The rules and also discuss yes.
We are proposing 7 days.
Now, after and second interested parties at a bare minimum, and perhaps the other interested parties would also want to, and first interested parties, and perhaps the fifth and eighth interested parties. Is that in order? Yes.
With that with regards to the current interested parties.
Make those directions of joinder in chambers after this. I may join, I may not join. But there will be a contact person.
My Lord, a mere process of statement. And my Lord, I will renew the request that I yes, sir.
So the earliest we'll be able to come back is 3 days.
Yes, sir. If that is the amount of time they believe they need, then we let them be entitled to that. And we ask. No, it's okay.
7 days to close of business 15. The other 7 days will then take us to the 22nd. Close the date. Council Mango.
Your Lordship, it's convenient.
So my Friday 24th is full. Physical or virtual?
Physical.
Physical. The earlier we start, the better. From 9:30, I will give you a Mendia could then give you a mention before me on the 24th, but I strongly suggest respondents, they are further directed to file the same
as an affidavit or an annexure to an affidavit second to seventh petitioners, applicants. I am optimistic. Second to seventh petitioner applicants with any of the respondents and interested parties within those 7 days afforded to the petitioner applicants. Mention before the Deputy Registrar on 23rd of January 2025 at 9 a.m. to confirm compliance. This will be virtually. It's just to confirm compliance with the availability of a mention before this judge on 24th January 2025 virtually if need be, but the same shall only be in exceptional, four exceptional circumstances. So mentioned before me on the 24th should only be something completely beyond case management. Hearing of the application on Monday, 27th January 2025 at 9:30 a.m. in open court / physical court. The attendance of the Inspector General of Police in person shall be required. The attendance of the Director of the third respondent or an authorized officer of the same shall be required, and for the avoidance of doubt, that other officer must be one who is well seized and informed of the matters and responses by the second and third respondent. All other respondents, previous directions on appearance by Apex officer or duly authorized person in the alternative shall apply, and the same shall also apply to interested parties who are bodies corporate. At 9:30 a.m., time allocations shall be given after hearing counsel and parties on their proposal as to how the hearing should proceed. So I'll leave the question of whether we will have persons taken to the stand to be cross-examined. I will leave that to that day. But of course I do expect counsel to build consensus so that we're not having a long drawn-out argument. So for example, if Thande Kuria is opposed, he should know your positions well in advance of then, so that he will say in 2 minutes we're opposed to this for 1, 2, 3, 4, 5. So unless I have missed anything, I've not yet put down my pen.
I don't know whether it is possible that
yes.
do a slight amendment on that fiscal appearance.
Yes.
When we have a hybrid system. But those will be joining online just to follow the proceedings, because some of us again will be the follow-up, rule and all. So we can just follow the proceedings but without any comments. I don't know whether that is
Mwalimu is available. They can interchange. He can be in the Court of Appeal and Mwalimu can come.
Also my experience with hybrid or virtual in high-profile matters has not been a good one. So, open court is very safe. Very safe. Yes. I thought I covered that. I thought I covered that. I said, with regard to the 8th respondent, they are specifically directed to file and serve as an affidavit or an annexure to an affidavit. With that, okay, good. Yes.
Video assistant. On that day, there are some links that would be.
Yeah, that's why you have mentioned before the DR.
Very well.
So, but our able DR is very, very good. You don't need to leave it to that formal mention. If you have any special requests, I believe those are slideshow. I had to authorize a slideshow. Had we gotten there, you'd have done a slideshow as well.
I made a request.
Yes.
And I thought the court would have benefited from our status report as to where the investigation starts.
Yes.
But obviously, those who are steering the matter for the petitioners have a different focus.
No. So you'll make the same arrangement. You will speak to the Honorable DR. You can speak well in advance of that. But any other issue you can bring up on that mention. You had mentioned a second one, Council Mango.
Yes, Your Lordship. We will have it uploaded on the CTS directions.
Immediately I leave here, I'll have a cup of tea and then I'll upload it.
Before you pen off.
Yes.
Before you pen off.
Yes.
I have been particularly interested in miscellaneous criminal application 2 and 6. For good order,
yes.
Again, may those orders also apply to that 7th last applicant in that matter, because I remember so well, and I don't know why my colleagues from the DPP are not expressing this. The only reason why your brother Justice Muteti did not strike it out is because of that particular person. If your orders that in 714 can also apply to 2 and 6, we can save the life of that 7th individual.
Is anyone opposed to me joining them?
His name is Kevin Mudhoni.
Yes, I joined
Just
him
one.
as the 8th petition applicant. Is anyone opposed?
My Lord, there is no opposition. In fact, I think VP just wanted the final bite. The last order you gave on the 31st was that all the orders you issue in 714 apply mutatis mutandis. I was here and he was in court at the same time.
When we went on the 3rd, your brother expressed that he should join this present petition. That's
we agree.
So by consent.
So by consent?
Yes. My good Arsenal fan and friend, Mr. JV.
Kelvin Mudhoni.
Yes.
Is added as the 8th petitioner applicant with immediate effect. So I will change where I've said to the 7th, it will be to the 8th petitioner applicant.
Thank you so much,
So is that all for this, so that I can return back to the other file?
My Lord, perhaps if learned counsel for the petitioner
yes,
is so kind as to serve the pleadings in respect of 216, the matter that was before your brother, Mr. Justice Muteti, and everyone, our response can now then be put on record.
In fact, we are not the petitioners. The advocate for the petitioner, for the applicants in that matter is Mr. Felix Keaton, and he has not come to court today.
No, he's well represented by my learned colleague. He has taken on a massive responsibility to ensure Let me finish. He has taken on a massive responsibility to ensure that that young man is joined as the 8th respondent. Surely asking him to serve the pleadings is not too much.
My Lord, the instructions counsel executed were sufficiently given to him by myself.
Counsel Ndegwa shall serve all other parties and counsel with the pleadings in Kibera miscellaneous application E216 of 2024. Close the business tomorrow? Would that be fair?
That's correct, my Lord.
By close
it's feasible
of business tomorrow. Now that file, which we had mentioned earlier, miscellaneous, it has now a new number, miscellaneous 1 of 2025. I'll not close it. What I will also try and do is to have the rest of you mapped onto it, but I'll not close it. So for this file, is that it for directions? So Mr. Guyo, call out the file I placed aside.
I appear alongside Mr. Keegan for the petitioners. Ndegwa.
Thank you. Mr. Barasa, what is your take?
My Lord, in that matter, I appear for the first and second respondent.
Mr. Nemodi.
May it please your Lordship.
Sorry, yes?
I appear for the third respondent alongside my colleagues, Mr. Monda, Mr. Witi, Mr. Jami.
Yes, I've recorded yourselves.
Yes.
So what is your take, Mr. Barasa? What do we do with this one?
My Lord, since the seventh petitioner has since been enjoined in number 714.
Yes.
My humble submission that that file be closed.
But we don't need to map anyone.
No, we don't need to map anyone. We can close it, or perhaps you can then note in the file that in respect of the seventh petitioner in that matter, the outcome of the other matter then applies to the file.
Been joined to the other one.
Then we can close it.
Yes, my Lord, I am the similar view that the file serves no purpose.
So court, for the reason of the addition the seventh applicant hearing to petition 714 of 2024 as the 8th petitioner therein, and with the consent of the parties in this matter, this file be and is hereby closed with no orders as to costs for the avoidance of doubt. Liberty to apply shall remain. You will have liberty to apply, but the file will be formally closed, effective immediately. So I think that is it for the day. Thank you to the parties and council in the matter. You have quite a heavy task ahead. I will not accept adjournments on that hearing day, please. So thank you very much.
No, yes, sir. I can tell you once. Nipo salama ndugu. How are you going on? Leo vizuri.